Oh, what happened? I just lost it. Hold on. There it is. Okay. We're going to give everybody a few minutes to come into this webinar. Looks like we have about 22 that have joined so far, so it's a good number. I will give it a few more seconds and then we can go ahead and begin.
Sounds good.
Gloria, can you check that dialog box out? It's blocking my view. Okay, we can go ahead and begin. Thank you and welcome to joining our webinar on the continuing impact of the coronavirus on estate planning. My name is Zara Buck-Whitfield. I am an associate director at the Earl Carl Institute. And before I introduce our presenter, I wanted to let you all know that we value your feedback on our presentations. And so throughout this particular webinar, we will be providing you with evaluation forms. I'm sure Attorney Nelsen would also appreciate your feedback. So if you could, we're gonna place that in the chat, and if you could fill it out and return it to us, that would be great. You're gonna return it to Gloria Suarez, who is our community outreach coordinator at the Earl Carl Institute. And also, we will be providing you with CLE attendance forms in the chat as well. Please take advantage of the QR code. You can hold your phone up to the QR code and it'll redirect you to the state bar, and you can self-certify for this particular course credit. So it is 1 MCLE credit and 0.50 ethics credit. Attorney Lisa Nelsen joined the Earl Carl Institute for Legal and Social Policy in October of 2019 as a staff attorney for the Opal Mitchell Lee Property Preservation Project. She provides representation in estate planning, probate, and property issues. Prior to joining the Earl Carl Institute, Attorney Nelsen worked in private practice, focusing on probate, estate planning, and elder law. She has a lifelong passion in public service and has volunteered with the Houston Volunteer Lawyers and the Houston Bar Association in pro bono and community outreach. As co-chair of the Elder Law Committee, Ms. Nelsen updated and rewrote the Elder Law Handbook. Attorney Nelsen is a native Houstonian. She has a Bachelor of Arts degree in English from Trinity University with a JD from Mitchell Hamlin School of Law in Minnesota. Prior to law school, she was a technical writer, but her passion was volunteering with social justice organizations. Her experience at those organizations inspired her to attend law school in order to better serve her community. Everyone, I present to you Attorney Lisa Nelsen. Thank you.
Good afternoon, everybody, and thank you so much for joining me today. I really appreciate all the students that have joined as well. I'm going to start out the presentation by giving you some pointers if you're not familiar with estate planning research. If somebody calls me and makes an appointment and comes in the door, I know that they're going to have estate planning completed, but so many people do not want to deal with estate planning at all. I have personal friends who they can't decide who would get custody of their child, so they just don't have a will. There are people that get too emotional thinking about the fact that they need a will. So I'm going to start out with some examples of poor estate planning becoming a disaster. Most people know about this. This is a picture of Prince from his performance at the Super Bowl in Florida. And if you haven't seen it, it's really amazing. He was even backed up by the HBCU band from FAMU. He should have used TSU's band, but I suppose he needed to use a Florida university. Prince's case is especially sad because he met with an attorney almost weekly. He was so concerned about controlling his intellectual property rights. Fairly often his attorney would say, we really need to talk about your estate plan. Prince refused. So when he died unexpectedly, it was a mess. He had, the only child he had predeceased him. He was not married at the time. And about 30 people came out of the woodwork, either claiming to be siblings, half siblings, or children. They had to spend, the state spent a lot of money on DNA testing and determined that he had one full sibling and 5 half siblings. In Texas law, if you have a half sibling, they only get 50% of their share. In Minnesota, the half siblings got exactly the same amount as the full sibling. And one of the things that has been really difficult to me as a fan, I love that we're going to get probably thousands of new Prince songs, but at the same time, I feel guilty enjoying them because Prince did not release those songs for a reason. He had such, creative control and quality was so important to him that he didn't want those songs released. He didn't want Let's Go Crazy to be a credit card ad. So it's really sad to see how he could have controlled things himself and had an estate plan that honored his wishes. I'm going to give one more example of poor estate planning creating a complete mess. This is the Great Aretha Franklin, a picture from the mid-60s. My husband and I saw the movie Respect right when it opened, and it's brilliant. I highly recommend it if you haven't seen it. Jennifer Hudson is amazing. But as we walked out of the theater, I turned to him and said, you know, they really missed a great opportunity. I was hoping part of this movie would be about the importance of estate planning. Miss Franklin, for great reason, had trust issues. When she passed away, there were over $1 million in uncashed checks in her handbag. They later found 3 handwritten wills among her personal effects. And it named her niece as the executor of her estate, and everything went to her 4 children. I just found out that this year they have found that she was working with an attorney for a few years for estate plans. And she had a will, but she never got it. She wasn't able to sign it before she passed away. Those attorneys are trying to bring forward that will because Michigan has a law that if you can demonstrate testamentary intent, they may be able to probate it. So, you know, again, it's quite sad because a lot of her personal business got out in the public, which she would never have wanted. And her 4 children have been fighting horribly. The niece resigned as administrator because she couldn't deal with the family discord. So today we're going to first of all talk about the estate planning documents, and I include the drafting considerations during COVID-19. I am starting to meet in person with a few clients to sign documents, but it's cumbersome because we're all wearing masks, we're socially distanced. If they have simple estate plans, I meet them out in the parking lot and bring a clipboard for them to sign it. And we're going to talk about document execution during COVID-19 and again, remote notarization. And then hopefully we'll have plenty of time for questions. If you have questions, please put them in the chat. Anyone who requests can get a copy of my slides, so I'm not going to use the time to go over all of these terms. The ones that we need to know for today's seminar: an attested will is a will that's signed in the presence of two witnesses. That's typically what you get when you go to an attorney's office, where, you know, the witnesses watch the testator initial each page of the will. The testator, who is the person who is signing the will sign it, and then the witnesses sign as well. Beneficiary is the person who benefits a person benefiting from the decedent's will. Decedent is another name for the person who passed away. Executor is the person who the testator names to carry out the will provisions. The executor is really the manager of that person's affairs to wind everything down. And another important term to know is one called self-proving affidavit. In Texas, we prefer self-proved wills, and the self-proving affidavit is the final page of the will, and it's a sworn statement that the witnesses and the testator sign in front of a notary public. It constitutes presumptive evidence that the testator signed the will in accordance with state laws. Testate is the name for a person dying with the will. Intestate is a person who does not die with the will. Testator is the person who makes the will. So an estate plan consists of multiple documents. You will always have a will. I'm going to go into a slight detail about trusts in a minute. They're always a hot topic. It can include trusts, but trusts are not necessary. Statutory durable or financial power of attorney, medical power of attorney, HIPAA release, the directive to physician or living will. There's a declaration of guardian in case the testator is later incapacitated, or a declaration of guardian if they have a minor child. Transfer on death or Ladybird deed, and appointment of agent for disposition of remains. I have a slide here that you will receive that lists the location of all of the different laws for estate planning. Texas, I always include this slide because clients are shocked when I explain to them that if you don't have a will, Texas law determines who will inherit from you. The biggest shock is when I explain that if you are married to somebody and you're living in a house that they purchased before the marriage, that person also has other children besides those in your relationship. Those children are entitled to half the estate. So I had a client once who was shocked when I explained that if her husband did not make a will, her stepchildren would be entitled to the house. She would get a life estate. You can, in Texas, the surviving spouse is entitled to live in the house for the rest of their life, but those outside children are entitled to half of the estate as well as the half of the value of the home. Will drafting considerations. It's pretty common that clients want to leave some children out. You know, they have the black sheep that they wish to inherit. It is critical that the client list every child, stepchildren if they have stepchildren, and grandchildren if they have grandchildren that they want to include in the will. You absolutely need to include those that you wish to disinherit. Otherwise, that opens you wide open for a will contest. They can say, well, my mother would never have disinherited me. She must have had dementia when she wrote this will. And then all of a sudden, all your well-intentioned plans are subject to a lawsuit. You do not in a will have to list specifically what you want each person to inherit. Pretty typically, it will be, if the person is married, I give everything to my surviving spouse. If my spouse does not survive me, everything goes to my children, my nieces and nephews, whatever, in equal shares. However, some people do have specific items that they want to give to specific people. I always recommend that in case you want to change your mind, you can have a list and keep a running list, or even put tags on the back of items so that your executor knows who wants to inherit specific items. But if it is incredibly important to you that this niece receive your special china, it's good to mention it in the will. A memo outside of the will does not have the same legally binding effect as a will. It's please follow this, but they aren't legally required. Another big issue is please tell them how important it is to have a trustworthy executor. A lot of times clients are so worried about hurting someone's feelings, so they think the best thing is to name the oldest child, or to name several children as the executors. I tell them, and this sounds really harsh, but I tell them, you'll be dead. You will not have to deal with any fallout. The important thing is to choose someone who will follow your wishes. It may not be a child. It may be your best friend. It may be, a cousin. But it's critical to have someone who will carry out your affairs. Will execution. This became a problem during the last year and a half. So I attended quite a lot of programs on what we could do in order to continue having wills, continue creating wills during that time. Technically, the testator, the person signing the will, does not need to sign in the presence of the witnesses. However, the witnesses need to sign in the presence of the testator. They do not have to be, people talked about options where somehow you've got a conference room with some kind of glass panels so that the testators can see each other, but everybody's far apart. The testator absolutely has to see the witnesses sign or be able to see them sign with slight physical exertion. So that would be if they had to move their chair over to a window, or they had to step up and look outside the door into the hallway. The notary is not needed for the valid will, but it is absolutely required for the self-proving affidavit. People talked about separating witnesses and testator with a glass panel, but you could end up being the first person who is challenged in court by doing that. So you want to be careful. Now that now that we're hopefully coming out of the tunnel, I have had a few clients come in being very careful. I also, at the beginning of the pandemic, had a will clinic for some women. They live in a residential facility, and we did it on Zoom. They met with two witnesses on their side where they were, and I was able to notarize the document. And I'll go over the details for how to do that in a minute. What we did, and I thought after I took the bar exam, I'd never need to know about this again. A holographic will is allowable in Texas. And during COVID, I started giving people instructions on how to do holographic wills. Holographic will has to be absolutely in the testator's handwriting. It cannot be typed and then signed. They don't have to write in cursive. If their typical way of writing is to write in print, to write in capital letters, that's fine. They just need to use what their usual handwriting is. And they don't have to have witnesses. It can be self-proved at any time during the testator's life. I had some clients with serious health concerns where they didn't want to take a chance of being around other people. And so I gave them instructions on how to write the will, and they then sent me a copy so I could review it and make sure that it was fine. What I advise them is once they're vaccinated and they're comfortable being out and about, to come to me, and we can either do an attested will or we can have a self-proving affidavit, just like I mentioned earlier. It used to be in Texas that you could dictate your will to another person. That is no longer legal. I had a case just recently where I unfortunately had to tell the client, the wife wrote everything and the husband signed it. That is not a valid will. This is the form we handed out to people so that they would know how to handwrite their own will. And now that we're coming out of it, I actually next week am probating a holographic will. My client was severely ill and needed a will desperately, so I sent her the instructions, and I'm interested to see how the probate goes next week. If they're not able to have the holographic will make self-proof later, Texas Estates Code requires that you have two witnesses who can testify that the will is in the decedent's handwriting. I've run into issues with this case and another one. How many people handwrite letters anymore? We communicate by email, we communicate by text. There's a lot of people that wouldn't know your handwriting. And you need to think about that, because I had my case next week, my client has friends of her mother's who recognize her handwriting, but they don't understand how to use Zoom, so they're not able to appear in court. So we're scrambling to find younger people who can recognize the handwriting. I had another case this week where I was getting ready to file my application for probate, and I called the client and explained to him that we needed two witnesses who would recognize his father's handwriting. He said, I don't know that there's anyone that would recognize my father's handwriting. He never wrote, he wasn't the type to write letters or send cards to anyone. And he reached out to some relatives and they said, no, we can't testify to that. So I'm trying to scramble to find another way to help this client. So I think holographic wills are a good substitute, especially in an emergency situation. Someone may be in the hospital, but they can lead to trouble down the road. Quick talk about probate versus non-probate assets. Probate assets are property under the testator's name that pass under a will. So that would typically be personal property like household goods, vehicles, jewelry, all their personal property. It can be their home as well. Non-probate assets pass according to contract law. That would be any financial assets with a named beneficiary. That passes under the terms of that contract and are not part of the estate. So that would be, if you have beneficiaries on any of your financial accounts, you need to make sure that those are correct. The important practice tip, I tell everybody, I do a lot of community outreach programs, and I tell everybody, when you get out of this presentation, call your bank, call your financial advisors, call your credit unions, and make sure that you have transfer on death or payable on death beneficiaries. That makes it so much easier for them because they can just go to the bank and handle the paperwork through the bank and immediately have access to those assets. However, it's critical to revise that, review that at least every 5 years. People change their names, people get divorced, people get married. I had a sad situation. It was a very small estate and he left it to a friend by her nickname instead of her full legal name. So they had to spend money on a probate when they shouldn't have had to spend anything to get access to that small account. Whoever promotes trust on different financial advice shows has great PR because everybody always wants to know about trust. In Texas, our probate system is, if you have a valid will and nobody's going to fight, our probate system is great. It is not that expensive, and it is relatively smooth if everybody's getting along. There are good situations to have a will. I still, with my clients at ECI, will do testamentary trusts when people have either a minor child or disabled adult child. So you want to make sure that it doesn't affect the benefits that the disabled child may have. It's a great idea that a testamentary trust is in the body of the will. And what it does is, upon your death, this trust is created for the benefit of this child or this disabled adult child, and it passes according to those trusts. Revocable living trusts are a hot topic, and they are a good way to avoid probate, and they protect the privacy of both the trustor and the beneficiaries. What happens is, this is something where if you file for probate of a will, it does become public record. And there are people are shocked at how much junk mail people get from people wanting to buy a house or something like that because they see that the probate has been filed. Revocable living trusts, everything happens outside of the courthouse. So it's completely private. That trust remains private. For people who want to see, now that would have been a great thing for Prince. He could have hidden all of his assets and made sure that they got to the people he wanted to get them to. Irrevocable trusts are great for Medicaid planning and for other tax planning, things like that. Revocable living trusts, you can change anytime you want to. You know, as your grandchildren get older, you can make them instant beneficiaries instead of having to wait till they're 30. So you can change it during the lifetime. Irrevocable trusts are very difficult to change once they're executed. They are used to help somebody protect their assets. The best example that I know of is so that someone can qualify for Medicaid for nursing home benefits. However, trust came up when we were talking about doing estate planning during COVID. You don't need witnesses to execute a trust. It is preferred that the trust is notarized, but it's not legally required. A couple of other reasons to have a trust would be if you have irresponsible beneficiaries that you know that once they got their inheritance, it would be spent like that. I advise people to think very carefully about what age they would want their child or grandchild to inherit, because even one of the most responsible young women that I ever met inherited from her grandmother when she was 18, and she said that money was gone in a year. She's kicking herself now. Also, if you want to maintain multi-generational wealth within your family, a trust is a way for you to control that those assets stay within your family. So my recommendations when we were right in the middle of COVID would be to have a holographic will and come see me later, either to have an attested will or make your holographic will self-proving. You can also have a revocable trust and a pour over holographic will. If you do estate planning that involves trust, they still need to have a will because there's always that one asset that they forget about. So the pour over will basically means that anything that I did not put in my trust before death will, once my will is probated, they will pour into my trust. Statutory durable power of attorney is the form where the client designates who they would want to handle their business affairs. This is another thing where you need to stress to them that they need a trustworthy agent because that agent could put them out on the street. I can't tell you the sad stories I have had where the son that was named the power of attorney steals money from his mother who's unable to handle her financial affairs. Legally, you can have more than one agent. I don't like it because those two agents always have to agree. I have allowed it in a situation where I'm sitting there and I can see that the family dynamics are great, everybody gets along and it seems trustworthy, but you have to explain to them that the person signing the power of attorney either has to agree that they have to that the two agents have to agree with each other or they can act independently. Finally, the statutory durable power of attorney is effective, either can be effective immediately or upon the client's incapacity. During COVID, I tell people to consider making it effective immediately. If something happened, when you have it effective upon the incapacity, you have to have a doctor's declaration that that person is no longer capable of handling their affairs. So you might want to consider in certain situations making it effective immediately. It's also good to expressly authorize the agent to communicate with others by electronic or telephone. Medical power of attorney is what you have when you are no longer able to communicate with your doctor. With a statutory durable power of attorney, if it's effective immediately from the time you sign that document, whoever you appoint as your agent can take care of your business for you. And a lot of people like that. Medical power of attorney, that person cannot act on your behalf until the doctor says that you are unable to communicate with them. It's a great tool to have, and if you ever have to go into either an outpatient surgery or inpatient surgery, they want you to have that power of attorney so that the doctor has a point person to go to if there's something arises. The form usually includes a HIPAA release, but it's also good to have a separate HIPAA release. The HIPAA release is the document that lets your healthcare team know who they are authorized to speak with. I provide a separate one because the one within the medical power of attorney is not effective until the medical power of attorney is effective. Now, one thing that I didn't mention earlier, but it's on my slide, for both of these power of attorneys, you need to use the form in the statutes. This one is in the Health and Safety Code. If you do not use the form used in the statutes, you may run into issues down the line. Especially with financial institutions, they are very careful about protecting your assets. Now, a lot of attorneys don't realize this. And people have their family attorney, their real estate attorney, whoever, and they just go ahead and have that person do their estate planning. Well, that real estate attorney may not know that the statute has changed. They did not change the statutory durable power of attorney in the last session. It may be changed in the session in 2 years, but it is critical in 1 year. So it is critical if you don't practice in this area regularly to look up that statute and make sure you're using the current form because things do change. And back to the medical power of attorney, it's really important to authorize, if you want experimental treatments, it's a good idea to have that listed within your medical power of attorney, that you consent to any experimental treatments that are needed. And again, to authorize the agent to communicate by electronic or telephonic means. Directive Disposition is popularly known as the living will. It's in the Texas Health and Safety Code as well. It is not legally binding, but it is a gift to your loved ones. It is a way for you to let your family know what your end of life decisions are. What you are stating is if your doctor says that you will die within 6 months, if you are not kept alive through life support, how do you want to go? Do you want to be kept alive as long as possible, or do you want to be allowed to pass peacefully? It's a painful subject. I was talking with our amazing intern this semester, Mr. Rhodes, and he said, I wasn't thinking about it. I'm just going about writing these documents, but that's a real person there. And I said, it's important to remember that. I had a clients who were brought in by their daughter. And when I went over the directive to physician, she started crying. And it really hit me, these are very important, serious decisions that everybody is making. In the directive to physician, there is a spot, if someone has a strong feeling about something, commonly people will write in that they do not want to be fed through a tube. You might want to think about it if you're in the hospital for COVID and you want a ventilator in that situation, you may want to write that in. However, there's a question about it among the estate planning community because the standard directive only applies if you're going to die within 6 months or if you're never going to get better. For example, you're going to be in a coma. This is probably, hopefully, unlikely for COVID treatment. Designation of guardian. We always hope that people do not need a guardianship. It is a very expensive, time-consuming process. You have to get strict, as it should be, there is strict court supervision to make sure that the guardian is not stealing or mismanaging or not taking care of their ward. So hopefully with a good statutory durable power of attorney and medical power of attorney, you will never need to have a guardianship. But it's important to have this just in case something happens. If, for example, in a situation where we found out that my client's son was stealing from her, the best way to create that was we got a guardianship of her so that that son could never steal from her again. The best reason for having this document is that your client can list anybody they do not want to be guardian. I like to know that they, make sure that we have covered everything so that somebody that would not act responsibly does not have the option to apply for guardianship. There's 2 types of guardians. Guardian of the person makes decision about your daily life, living arrangement, healthcare, everything related to your comfort and well-being. The guardian of the estate manages your property and finances, so they act like the statutory durable power of attorney. Second one is the designation of guardian for minor children. It's pretty much the same as a designation in case the need arises, so that you choose people who will take care of your children if you should pass away while they're still minors. And again, the most important thing is to list people you do not want to be your child's guardian. However, a lot of clients think that this is a great way to override the rights of the child's father. They cannot use this form that way. Parental custody agreements are solely determined by the family court orders. They can't override it this way. Transfer on death deed is a relatively new law. We also have what is known as Ladybird Deeds in Texas. Both of these are deeds that allow the real property owners to name a beneficiary for that real property after they die. They retain full ownership rights during their lifetime. It must include the full legal description, and it has to be recorded in the real property records in the county where the property is located prior to the death. The deeds are revocable. They can change it as many times as they like, revoke that prior deed, have a new deed, leaving it to somebody else. I love this for 2 reasons. They don't have to probate to get title to your house. It saves the beneficiaries time and money because it's a pretty simple process. They go to the clerk's office, show the death certificate, show their state issued ID, and they're able to transfer the home without having the time and the expense of a probate cost. There's also, you will hear people a lot of times saying that they're worried about the state taking their affairs, taking their things. That's called the Medicaid Estate Recovery Program. If someone uses Medicaid, for example, to pay for their nursing home benefits, if you probate a will transferring property, the MERP program can seek reimbursement of what they paid on your behalf. If you do not go through probate, so you use a Ladybird deed or a transfer on death deed, you can avoid that reimbursement process. It's perfectly legal. It is the way the law has been written. A lot of people will talk about Ladybird Deeds or revocable life estate deeds. Those are more or less the same thing. There are no statutory provisions for those deeds. It's based on common law. Transfer on death deeds are in the Texas Code. The last one, and I used to not always realize how important this is. If you don't have an agent who determines what to happen with your remains, your family controls what happens. You know, this is a concern because there might be somebody who feels very strongly about what they want. You know, I've had clients that absolutely do not want to be cremated, or they want to make sure their body is donated to science or to an academic institution. This way, you choose someone you trust who will make sure your wishes are done. Years ago, I had a client who had no family. He was very lucky to have close friends. When he passed away, his friends knew that he wanted to be cremated, but it took going through a lot of hoops because we did not have the appointment of agent for disposition of remains. The default, if you don't have that agent, is to be buried. Now, finally, one thing great that happened during this time, on April 8th of 2020, the governor suspended the physical presence requirement for notarizing certain documents. It's not everything. It's mostly real estate documents and some estate planning documents, but not all of them. The order is still in effect. I checked yesterday. It has been renewed for the month of October. I check at the end of the month, every month, to see if I can still notarize documents remotely. These are the documents that can absolutely be notarized remotely: your statutory durable power of attorney, your medical power of attorney, the HIPAA release, the directive to physician. And I am incorrect about the directive of declaration of guardian that needs to be witnessed. The transfer on death or Ladybird deed do not need to be witnessed. They just need notaries, and the appointment for agent for disposition of remains. So throughout this time, I have been meeting on Zoom with clients to get those documents notarized. Holographic wills and trusts do not require witnesses or notarization. Like I said earlier, I have had situations where the client is able to get in a large conference room and socially distanced. Witnesses can be far away, and I watch each person sign. Feel perfect. I absolutely have to see the client and the witnesses see the documents, signing through Zoom, FaceTime, anything like that. If you do not know the people, you need them to hold up their ID to the camera so that you can verify their identity and put that information in your notary book. Best practice, how this absolutely should operate, is you're on Zoom, they sign and witness the documents if needed, and they need to immediately fax or scan and email the document to the notary. They remain on Zoom, the notary notarizes, returns it by the same method. That is the absolute best way. We've run into a practice consideration with that. Many of our clients do not have access to technologies. I have had them mail the documents to me, which is not ideal. But at the end of the day, what I want is for these people to have their estate plan, so I work around whatever limitations we can have. Here is my contact information. You can also get it through Ms. Suarez, and I can put my email in the chat. But it has been great talking to you, and I'd like to open it up to questions. I'll take a look at the chat to see what I can find. I think a lot of it is housekeeping. We've got all the links for registration. Okay, the QR code is in a document that Ms. Suarez added to the chat, I believe. And you would have to hold your phone. You need to be patient because sometimes it takes a minute for your phone to register that QR code. And I think I saw a couple of people ask if we report. You are responsible for self-reporting. So please find that form in the chat and you can report your credit to the bar. And let's see.
The QR code to register for the next CLE is, I'm putting it up now.
Okay. Attorney Nelson, you have a question. It says from Reginald McCamey, and he says, can you talk about revocable and irrevocable advantages and disadvantages?
Absolutely. This is going to be fairly basic because I could give you probably, a full day CLE on trust. But just briefly, there are advantages. The revocable, the great advantage is you can change it throughout your life. So I know people that want to make sure they want to bypass their children, and they want to make sure that their grandchildren, for example, have money to go to college. So they will, as more grandchildren are born, change the trust to add those new children. As the grandchildren become older, they may change the requirements of the trust. So the revocable living trust, the advantage is it's revocable. You can make changes for the rest of your life. The other advantage for the revocable trust is it's private. It will not go through probate court, so it may be quicker than probate, and you won't have, when you file for probate of a will, that will becomes part of the public record. We file the will with the court. And so anybody can see what your business. So a lot of people that want privacy, they don't want anybody to know their business. A trust is great because that will never be publicly accessed. The irrevocable trusts you cannot change them. I think there are very minor reasons when you can change them, but for the most part, they're irrevocable. The benefits for that are for different types of asset planning. For example, somebody who has a child who is irresponsible. Maybe they have substance abuse issues. Having an irrevocable trust for them will let you know that they won't, if it's somebody who, if they got the money, they would just go buy a sports car, they'd take a trip. You want to make sure that they're forced to use that money responsibly, or the real property, whatever it is that they inherit. They cannot change it. That property remains owned by the trust, and so that irresponsible child would not be able to waste those assets. And the other, the main reason that I used them back when I was in private practice was to qualify people for Medicaid benefits. So what would happen with what happens with Medicaid is currently it's a 5-year look back rule. So Medicaid absolutely does look through in great detail all of your transactions during the last 5 years. And people think they can hide stuff. You cannot. They will look through everything. So if you transfer everything to an irrevocable trust before that 5-year period starts, that property is no longer owned by you. It is owned by whoever the trustee is. That trustee controls your estate, and they can spend everything on your benefit. They can it's your money, but you no longer have control to go to the bank and make a withdrawal from your account. That trustee is the one that you communicate with to say, I need money for car repair. I need money for medical expenses. And they will then pay those bills on your behalf.
Okay, and Reginald follows up with another question. He says, are there any forms that are good to use?
No, there are forms you want to go to an estate planning attorney if you're not one yourself. I don't even know how many different systems there are. Different attorneys use different systems. There's one that I think it's called Texas Docs that I have looked at a little bit. It's less expensive, and I think it's pretty good. I couldn't give you a full form. A lot of people like the O'Connors and Davis estate planning forms. There are a lot of other programs that some elder law attorneys get into that are quite expensive. But if you join some elder law estate groups, you can learn more about those. And I saw a question in the trust about the elder law handbook. It is now available online. And I'll put my email in the chat, but there is on the the Houston Bar Association website, you can get access to that elder law handbook because it has been updated again. We try to update it every couple of years because laws change.
Lisa, when we emailed the presentation, your presentation, we'll just add that as an attachment.
Perfect. I'll send the link to Ms. Suarez.
Okay, thanks. Are there any other? Go
It
ahead.
is available in English and in Spanish, which is a really great resource.
Okay, wonderful. Are there any other questions? I see one in the Q&A. Hold on one second. Okay, from Anonymous. It says, what advice would you give to a lawyer that wants to transition from one area of law to estate planning?
Give me a call or email me if you like. The best advice that I can give you, it's what I did when I first started out in the practice. I was in a general practice, did a little bit of everything, which was good because I got a lot of different experience, but then I transitioned into this. What I did is I went to as many CLEs as possible. There is a Texas probate listserv. They are the nicest people. They do not mind, they do not have any questions at all. If you want to focus on a very great specialized group, it's called NALA, National Association of Elder Law Attorneys. They're a great organization and they have chapters all over the country, including in Texas. They have conferences here. They're a great resource to join. If you're a member of the Houston Bar Association, we have an elder law committee. That's a great way to get experience. And we also have a probate, trust, and estates program that has, it's not expensive to join at all. And they have great CLEs for about 9 months of the year. So that's another great way. So I just say, look out there for the organizations available. The State Bar has one that's real estate, probate, trust law. I think I'm getting it right. The acronym is REPTL. They have a lot of great resources. So what you want to do is get out there, contact your local bar associations, contact attorneys who practice in the area, and there is a wealth of resources you can find. Another great, one last reference would be UT Law School has a CLE every August. It's a 2 to 2.5 day CLE that's only elder law. It is excellent. And I went to that when I first started practicing in the area, and it was a wealth of information. Thank you.
Thank you.
We have another question. What advice would you give to a lawyer that wants to transition from one area of law to estate planning?
I just answered that one.
The next question is coming from Blair Woodard, and the question is, how far in advance does an irrevocable trust need to be set up before a client needs to apply for and use Medicaid?
5 years. So you would need to set it up while that person is still in good health, while you know that they won't need to go to a nursing home anytime soon. So, you know, I had a client who was in her 60s, but she had a severe kidney ailment. She was already in assisted living because her health was so poor. She had numerous chronic conditions. When she and her husband got divorced, we had her divorce settlement into an irrevocable trust because we knew, even though I think she was just 68, we knew that it was going to be sooner rather than later when she would need skilled nursing care. So, you know, if they're happy, if they're very healthy, you know, their 70s is just fine, but you want to make sure you do it well in advance of that 5-year period.
Are there any other questions? You can put it in the chat or put it in the Q&A box.
Thank you, everybody, so much for coming. If you're a law student, please feel free to give me a call or give me an email. I'm glad to talk with you. And we have a wonderful intern program if you're interested. And we want to thank you again. Every October we have a CLE series. Next week it is housing stability. It will be with our newest attorney, Stormy Clark, on eviction defense. October 22nd, we have one by our Associate Director, Kelly Austin, on foreclosure defense. And finally, on October 29th, the juvenile justice defense. And again, there's a QR code if you would like to register.
And we've placed links in the chat. You can also go to our Facebook page. You can register through our Facebook page. You can also register through our Instagram as well. And we've also placed our evaluation form in the chat, as well as our CLE attendance form is also in the chat. If you could complete those with your CLE attendance form, you can self-certify with your evaluation form. If you could return it to us at your earliest convenience, we'd love to hear and get feedback from you. Thank you.